even if you have been living under a rock, there would be no way you do not know of Vishnu Jain. The legal fight he has put up for the Gyanvapi, in the Gyanvapi case, his very public support for the Waqf Amendment Bill, and so many other causes that are very close to his heart as well as the hearts of millions of Hindus in this country. Vishnu, thank you, and thank you for giving us time for this interview. I can start with Gyanvapi, but let me start about something that piqued my interest this afternoon from your speech at the Pondy Lit Fest. You spoke about the Netflix series Maharaj and how you found it very problematic. Could you expand on that?
See, we actually did a lot of research on this Maharaj movie, and not just on the movie Maharaj per se, but the background of the movie. Now, if one analyzes the entire background of the movie, there was an article written by a very revolutionary journalist, as was portrayed in the movie, and the name of the journalist was Kanchan Das. So, he wrote an article in 1861 which was found to be very libelous. Now, the point is what is shown in the movie. I will come to movie a little later, but let's talk about the first principles. If we read the article, in the article a Sanskrit shlok has been quoted and a translation is there, which is also part of the judgment of Supreme Court of Bombay in 1862. That very verse is not there in the original scripture. And what is the article? The article is that you have to offer your wives, your daughters to Maharaj. This is the crux of that article, and it is quoted that it is mentioned in our scriptures. So, Sanskrit scripture is brought in the article, and the Sanskrit scripture says that all the devotees of Maharaj, Vallabhacharya Sampradaya, have to offer their daughters and wives to the Maharaj. Now, when we went through the original scriptures with lot of sense of responsibility, I must tell you that there is no such Sanskrit verse in any of the original scriptures of Vallabhacharya Sampradaya. So, point number one is that that article was based on wrong facts. That is point number one. Point number two, when this article was challenged by Maharaj in 1862, the Honorable Supreme Court of Bombay said that this article is correct, and they went beyond the zone of consideration. Now, I have a point of caution here and a point of caveat here. The caveat is that I am not defending what Maharaj did in 1862, because that's a factual aspect, and judgment so far as that factual aspect is concerned, after 170 years no one can say what happened factually in 1862. But my point is, and my concern is, that where the judgment of Supreme Court of Bombay of 1862 has gone beyond the zone of consideration, there where the problem lies. Now, for example, at page 218, and it starts from 210, all the objectionable parts of the judgment, it is quoted, it is mentioned that Srinathji is an Epicurean god. The devotees of Lord Krishna have been called as they are involved into adulterine kind of pleasure, and they are involved in group sex and orgy. And the Vallabhacharya Sampradaya, the entire Sampradaya has been painted with the same brush. Now, the point is this, that if there is anything erroneous which is happening in any Sampradaya, will you look at the individual cases, or will you paint the entire Sampradaya with the same brush? You will paint the entire devotees with the same brush. You will paint the God, which is our Dharma Sanstapana God, with the same brush. So, the zone which was there before the Supreme Court of Bombay was to adjudicate whether this article is libelous or not. But the Supreme Court of Bombay, the two English judges, went beyond the zone of consideration, and they gave these egregious findings which are affecting, which are infringing my right under Article 25 of the Constitution of India. The third aspect is the book of Saurabh Shah, which comes in Gujarati, which virtually is based upon this judgment of 1862, and there are certain additional comments which has been made in the book. And then the fourth part comes is the movie. So now the entire movie, if anyone will watch, the protagonist of the movie, Kanchan Das, is shown as projected as a very revolutionary writer. And it is also shown in the movie that Kanchan Das was having a fiancée, and that fiancée was involved in Charan Seva of Maharaj. In the judgment itself, it is mentioned that Kanchan Das had no personal acquaintance with any of the practices of Maharaj. But despite this fact, a wrong picturization was done on the basis of erroneous facts. The first principles were not looked into. That is a very important aspect. So my concern is, when this movie was challenged before the Gujarat High Court, the front line of defense of the movie makers and the Netflix was that this movie is based on the 1862 judgment as well as on the basis of the book of Saurabh Shah. The point is this, that no one is defending what happened in 1862, or if someone is misusing their liberty as a guru, obviously it has to be questioned and it has to be challenged. But the point is where the Supreme Court of Bombay has gone beyond the zone of consideration. That is the point of concern. And also, I have a grievance against the movie makers in Maharaj, because the real facts have not been shown. Suppose, for example, if you are making a movie on Bhagat Singh, will you put your imagination into that historical movie which you are making? So when you are making a movie on the basis of historical facts, historical fact was that Kanchan Das was not having a fiancée. Kanchan Das' fiancée never had any kind of relation with any Maharaj. But this was wrongly projected in the movie. So Maharaj movie is the last part of the grievance. The first part of the grievance is the article. The second part of the grievance is the judgment of the Supreme Court, where the comments have been made beyond the zone of the consideration. Then the poster of the book of Saurabh Shah. Apart from the poster of the book of Saurabh Shah, the contents of the book, and then certain portions of the movie Maharaj.
Would you also accept that sometimes it's not just back in the day, but sometimes while pronouncing judgments, certain things are said which hurts religious sentiments even till date?
Definitely, it's happening that there are now we are in the zone of live streaming,
right,
where the court proceedings are being live streamed. So there are many areas where the courts till today go beyond the zone of consideration. So I would like to reframe the issue in this way, and I like to give an example. Suppose, for example, in Ram Mandir's case, the Places of Worship Act 1991 was not under question, was not even a debate, was not even under challenge, because in the act itself Ram Mandir was exempted. So then also the Honorable Supreme Court went ahead and made certain observations so far as the validity and so far as the legality of Places of Worship Act is concerned, which was not the zone of consideration.
Right.
So many a times I feel that the judgments of the Honorable Court must stick to the zone of consideration, must stick to the issues which are before them, and anything which is beyond that, definitely we know that it's a strict legal principle that it is obiter dicta, but the fact it's a part of the judgment and it has to be struck down, it has to be taken off the record.
Right. Vishnu, you have lended your support very publicly to the Waqf Amendment Bill. Would you like to talk about it a little bit?
See, I personally feel that the Waqf Act 1995 is a very draconian piece of legislation. It completely violates the fundamental rights enshrined under Article 25, 21, 27, 300A of the Constitution of India, and therefore I raise this voice that these certain provisions of the Waqf Act 1995 have to be amended. Now we have come halfway mark, or I can say more than halfway mark, where this amendment bill has been brought in by the central government. I welcome the amendment bill, but I personally feel that there are still certain sections which are left from being deleted. Like for example, the provision which is section 8 of the Waqf Act 1995, where the provision is that for the survey which has to be conducted for these Waqf properties, the cost will be borne by the state government. This provision has not been deleted by the central government because it is completely in violation of Article 27. No such provision is there for any other community. Apart from that, under section 55, the Waqf has the power to remove encroachments. No such power is given to any other section of the society. So this provision has not been deleted. The budget of the Waqf, which is there under section 44, which gives the Waqf a central power, a central fund which is created for the benefit of Waqf, is not required, which was not there in the original provision in Waqf Act 1923. That is not being seen by the present amendment. Apart from that, the Waqf tribunal, I personally strongly believe that this entire tribunal is in violation of Article 323A and Article 323B. This tribunal must be deleted, it must be abolished, but that has not been done in this present amendment. Section 101, which gives the right of the members of Waqf board and mutawallis and everyone as public servant, that has not been touched upon. Apart from that, if you will see the provisions of section 108, where the evacuee properties which were belonging to the central government was the custodian of these evacuee properties, that has to fall back to the central government. For section 108 has been deleted, but how these properties will go back to the government, for that there is no provision. Then the last issue is that in the present amendment bill, it has been brought as a piece of legislation that no one will have the power to declare any government land as Waqf property. But so far as the land of other communities are concerned, no one will have a right to declare that land as Waqf property. That also has to be brought in. Apart from that, there has to be a national level inquiry as to the properties which have gone within the purview of Waqf. The zone under section 3B is that these inquiries will be conducted by the collector. So I personally believe that this will not be a very fruitful piece of legislation, because collectors function under the dictates of the state government. So there has to be a national level inquiry committee which has to see, which has to look into this aspect, that as to what are the properties which has gone within the purview of Waqf and how it has to be brought back and it has to be given to the original owner. So these things are lacking. So the intent of the government is very good, that they want to remove the draconian issues, draconian areas in the Waqf Act 1995, but still certain lacunas are there. So I am going to appear before the JPC probably on 8th of October, and I am going to highlight these issues before the JPC.
Right. Tell us something about what's happening with the Gyanvapi case, because the nation wants to know.
See, in Gyanvapi case, I must admit that after 31st of January 2024, the case is progressing at a very slow pace. For 3 to 4 months, there was no district judge which was appointed in Varanasi. Then there was a holiday, the courts went for summer vacations in June. From July, the district judge was appointed. The case is fixed on every Saturday, and there are strikes and condolences in the district court of Varanasi, and mostly there are adjournments which are being given. So the case is going at a very slow pace, and actually there is no hearing, there is no development so far as our 7 suits are concerned in Gyanvapi. We have filed an application before the Honorable Supreme Court asking the cases to be transferred to the Allahabad High Court, and it should be given before a full bench of 3 judges for original trial and speedy trial within a mandate of 6 months, because we are completely well versed with the facts as well as with the evidences which we have collected in this duration. So we are ready for the trial. So we actually want that there should be speedy trial. It should be decided within 6 months, within a particular time frame, and it should be decided by the Honorable Allahabad High Court, because it has a lot of constitutional questions involved. So as of now, I have no problem in admitting in front of you that the Gyanvapi case is going on at a very slow pace, but we are trying to we are putting in efforts so that through this judicial system we can bring the case back into the arena where we can actually argue and finish it off, and we can actually get a verdict by the Honorable Court.
2 last questions, I'll put them to you together. First, where do you get the energy from to fight these impossible fights? And number 2, how do you define yourself primarily, as a defender of your faith or as a legal luminary?
See, so far as the energy is concerned, actually energy, I will put it in a different manner. It's not the question of energy, it's the question of reading history. Suppose, for example, I'll give you a very layman example. If someone comes to know that their forefathers have been slaughtered, their wives and their daughters have been defiled, and if you come to know your temples have been demolished, destroyed, your idols have been desecrated, which recently happened in Bangladesh,
Yes.
whether you will, as a community, as an individual, you will not have that conviction to get back your dignity restored, whether you will not have the conviction to fight for these issues and raise it before the institutions, that we also are a part of majority community, but we want our dignity back. If there are laws which are draconian, which are discriminatory, which are making Hindus as 8th class citizen, 9th class citizen, 10th class citizen, our temples are being acquired, laws and laws are being made which are discriminating Hindus, whether we do not have the conviction to fight for this. So actually it's not about energy, it's about conviction. I feel that this entire civilization has been betrayed. The partition of this country happened on the basis of religion, and despite that, we have been converted into a secular country. This amendment which has been brought into the constitution, which is 42nd amendment in 1976, is very draconian, no one would have ever heard of. So these are the things we keep reading, and these things when we read, and this discrimination and injustice which is happening with the entire community actually reverberates and shocks our judicial minds, our legal minds. And as a lawyer, it's my duty that I donate, I contribute to the community. So this is just a small endeavor which me and my father and my legal team is making. So that is the only thing. We do not define ourselves as defenders of faith or any legal luminary. We are ordinary individuals. We are part of this civilization. We want that the injustices which have been done in the past must be rectified, and a message must be given by this great country, by our great democracy, that pen is mightier than the sword.
Great. Vishnu, thank you so much for your time.